Welcome to Learn Laws, where knowledge is power, not legal advice, just for education. Need real counsel, don't roll the dice. Always speak with the license discerning.
Welcome to Learn Laws. I'm James White, and we're here with Andrew Easler. And a hot topic today, in my ordinary course of research for the podcast, something that keeps coming up is evictions, especially with all the tariffs that are being levied and then not levied and then levied. A lot of businesses are freezing up; they're not hiring anymore. And with the invent of AI and AI agents and process automation, a lot of people are losing their jobs, or the economic activity is kind of almost frozen right now. So a lot of people are losing their jobs and they can't afford rent. And at the law firm, we're seeing a pretty large increase in landlords calling for eviction services. So I thought this would be a good podcast to explain how Florida evictions work in general. Both residential and commercial. Mm-hmm. So my first question to you is, what starts the eviction process?
Yeah, so the eviction process is going to start with a notice. So typically, the landlord is going to discover or learn in the due course that there's something that the tenant is not doing that they're supposed to be doing. And I bet you can guess what the most common one is.
I would assume it would be non-payment of rent from my experience.
Non-payment of rent. You're absolutely right. And for that one, you have 3-day notice that you're going to be giving the tenant.
And so that notice is it called the 3-day notice to vacate?
It is, yes.
Okay, perfect. So what has to be included in the 3-day notice?
Yeah, it's really 3-day notice to pay or vacate, right?
Gotcha. Okay.
Are there, if you want to stick around, then you got to pay me. If you don't want to pay me, then please leave.
Okay, so what happens? So on that 3-day notice, what has to be included? Obviously, the amount they owe, right? So what is that amount they owe? Is it just the rent they owe, or does it include late fees, penalties, interest, anything? Like, what does that notice have to include?
Yeah, the notice has to include all of the amounts that you're going to be claiming as owed under the lease as rent.
Okay, perfect. Plus any late fees, right?
Well, if late fees are included in additional rent under the lease, then yes.
Okay, perfect. So if they owe you, if the tenant owes money and you're looking to evict somebody, you do the 3-day notice, mm-hmm. right? You would, on that notice, you would add what they owe you with the base rent or the rent, and then if there's any late fees allowed to be charged or levied between the lease contract, then you would obviously add that to the 3-day notice to vacate.
Correct.
And go from there. Okay, what's the difference? Because I hear this all the time in my consulting practice. What is the difference between a 3-day and a 7-day notice?
Yeah, so the 3-day notice is for non-payment. Hey, you haven't paid me. A 7-day notice is, hey, you have not met your other obligations under the lease as a tenant. With residential, those obligations are a lot less than they are with commercial.
Gotcha. So give me an example. So 3-day notice, we already know it's non-payment to rent. It's either pay me now or pay me within 3 days, or we're going to start the eviction process or leave, right?
Right.
Or leave or start the eviction process. And then the 7-day notice would be like your lawn is not mowed properly, or there's some sort of like defective thing that you caused.
Yeah,
right?
So probably the most common type of 7-day notice we get is for somebody not maintaining the property. And usually the tenant says, oh, well, it's not my responsibility to maintain that property. But if you or your guest or your invitee broke a window, you're responsible for fixing it. It's not the landlord's responsibility to go in and replace a window when you're the one who caused it to be broken.
So if damages are caused or you're not living up to your lease agreement, then that 7-day notice would be delivered to you. Now, question for you, does the 3-day notice and 7-day notice have to be sent by registered mail? Because when I first started my rental business here in Florida, I was confused about this, right? Because how do you prove that you actually gave the 3-day notice? So with the 3-day notice, what I do, and you can let me know if I'm wrong, right? Which I don't think I am, but I could be. When I do the notice, I put the 3-day notice on the door and I take a picture of it with the time and date stamp or the metadata to prove that I actually delivered that notice on the specific date and time that is allowed for the 3-day eviction proceedings to start. Is that correct?
Yeah. So the statutes are very clear, and they say you can post it where as long as you know that they're there and they're present. Even if you think that they may have abandoned it, if you don't have another address to provide it, then you just post it there on the notice on the door, and you can take a picture of it as a record. And then we can utilize that if we need to, if somebody's going to contest whether they receive that service.
Okay, perfect. Now, what I also hear about 10-day notices. Like there's 10 and 14 and like 21-day notices. What are those? Are those, I would assume those are commercial, just based on my experience.
Yep.
But is there like, so can you explain what like a 10-day notice would be for commercial and like a 21-day or 14-day notice? Or is that specific to each lease contract if it's a commercial lease?
Right. So if you were to pull up the Florida statutes today, you would see under Chapter 83, you would see the first portion of it is for non-residential tenancies. And that is another word, a legal word for commercial tenants. And then the residential tenancy starts in Chapter 83, subsection 40, and that's where the residential tenancy laws are placed. This is one of the places where some landlords who are doing it on their own, we call it pro se without an attorney, kind of get things mixed up. Okay,
Happens a lot, right?
It does, right? So if you're looking up and you're trying to figure out where things are and you overlook the header and you see, oh, non-residential tenancy, you don't know that that really means it doesn't apply to a residential tenant of yours, then you might be looking in the wrong statute and there's a totally different standard. When it comes to commercial tenancies, it's a little Wild West, right? There's a lot of protections in place for somebody who's going to be living in a home, right? We treat them a lot better as consumers because we find that they're going to be, on average, less sophisticated, right?
Yeah.
And we also want to make sure families are kept together and they have rights and due process and everything is fair and reasonable for those consumers. But once you get into the sophisticated realm of commercial tenancy, things are kind of a little more dicey.
It's like a cupcake. So with my experience in commercial leasing, a commercial lease is like a cupcake. You've baked a cupcake and you can put sprinkles and icing and kind of anything you want on that cupcake. So it's like you said, the Wild West, where if you want to have particular terms and clauses in your agreement, you know, those pretty much fly because it's commercial. Obviously residential, like you just said, is there's more protections for people because they're obviously may not be as sophisticated, or they may not have lawyers on hand to review that lease agreement, which we always recommend. That's one thing. If you're a tenant watching this podcast, you know, sometimes it's worth it to pay the couple $100 for a consultation fee and just go to an attorney and understand your rights, rules, and responsibilities of a tenant. Because that can avoid a lot of problems.
Absolutely.
A lot of problems. So what happens if the tenant ignores any notice? Like obviously the 3-day notice, after 3 days, I would assume that either if you're doing it pro se or you're using an attorney, they then start filing the eviction process to get you out of the property. But what happens if they ignore like a 7-day notice or a 10-day notice for commercial properties or just any notices in general?
Yeah, so the notice is there to give the tenant the opportunity to address the issue, right? That's your opportunity. Hey, the landlord thinks that you're breaking the lease. If you don't think you're breaking the lease, you made a payment or something, that's your opportunity now to go back to the landlord and say, hey, I paid you that money you think I owe you. Hey, I don't owe you this late fee. That's not in the lease. You just made that up, right? That's your notice and your opportunity to defend that position. And ideally, if you have a position that's contrary to the landlord, then you should get that in writing.
Yeah,
right?
I mean, obviously, of course,
Right?
yeah.
And maybe send a letter back with tracking on it that says, hey, here's a copy of the deposit receipt where I paid it into the account you told me. Obviously, there's a misunderstanding. Stand down.
So
call me if you have any issues, that kind of thing.
So that opens up a can of worms for me, because if you said get it in writing, so I'm a landlord giving notice, you're the tenant, and you say you want to get it in writing. So would a text message suffice for that notice?
Nowadays, it's very common to go through text messages, have them printed out and read in court.
Or email or something like that, as long as you get it in writing. The key is get it in writing. So if you're negotiating with the tenant and they're saying, hey, I'll pay you, or if you're negotiating with the landlord and the landlord says, hey, I'm not going to evict you if you pay by Friday, and they start the eviction process on Thursday, well, now you have something in court to prove, hey, they told me I had till Friday to pay, and this is how I'm going to pay. So the eviction's kind of, gets thrown out, or whatever the case may be. Am I correct in saying that?
Yeah, I mean, obviously, if they started the eviction on a Thursday, they would then have to pay for a process server, and then that usually takes another couple of days to come out. So it's a process that takes a while, and they can always go back and dismiss the case. But if they brought the case wrongfully, and I think that's something that we probably should talk about today, is wrongful eviction.
Yes, I got that coming up in my questions for you, because I'm preparing for this, because I have all these questions myself. And when people call me, I'm like, hey, that would be a good question for Andrew, right? Ask Andrew, the attorney. So how fast could a landlord file in court, right? So I want to evict my tenant. let's talk about residential first, and then let's talk about commercial, because I know commercial is unique, right, for Florida. But how fast? I serve my 3-day notice. Do I file the next day the eviction proceedings and then serve it? How does that work? How fast?
Right. So the it's in the name, right?
Yes.
So you have 3 days from the date that you're supposed to have received the notice to respond or comply, right? And when I say respond, I mean respond with whatever defenses you have for why you haven't paid or why you haven't complied with the original notice. The 3-day period starts the day after it is posted. So if you get you get it posted on your door at 10 o'clock in the morning on a Tuesday, then your 3-day period is going to start on Wednesday, Thursday, then Friday, and then on Monday is when they could file that complaint for eviction.
So you have to have a full 3-day notice.
Correct.
Okay, perfect. Now, what does the tenant have to do when they're served? Obviously, the 3-day notice, we already discussed that they have to pay the rent or leave the property, right? And I don't want to leave the property because I have nowhere else to go. There's always, an excuse or always something, obviously, right? And some people do have hard times. That that's not their fault. They're good people, but they just run into hard times. So, what's the tenant's responsibility in responding to those notices, or to say they get served for an eviction because they haven't paid their rent or they haven't cured their issue? What's that process like for the tenant?
Yeah, so the tenant really, there's what their legal obligations are, and then what is probably practically best practice for them, right? So best practice is to communicate with a landlord or the person that is managing the property, whether that's a property manager or a lawyer, if they've hired a lawyer to do the notice. Sometimes we do that as well. So communicate. Right?
Yeah, that's number one. I mean, I have a tenant issue right now where, great tenants, I've always paid on time. They ran into a little bit of a problem with somebody paying them. Yeah. They've communicated with me. I followed up weekly, obviously, because I don't want this to continue on. Because if a tenant can't pay their rent on the 15th, how are they supposed to pay their rent on the 1st, right?
Right.
So I'm really trying to push that tenant to pay me, because I know when the 1st comes, if they haven't paid me by the 1st, now we're behind 2 months, and the eviction process, now this is a commercial property, but the eviction process will take longer, right? So my goal as a landlord is to mitigate my losses. And to do that, I have to start the eviction process as soon as possible. But because of my relationship with this tenant and what we've done together, I'm giving them a little bit of a break, because I understand right now it's an economically challenging time. Right. So I think communication is the key. If you communicate, most landlords, I think, personally want to keep a tenant in there, and especially if they understand that there's economic hard times right now, or there's some issues going on with trade and politics, that most people are going to be willing to give somebody a little bit of a break, right? Obviously,
if they can,
yeah.
Right? Obviously, economic hard times, really also tie the hands of the landlord. What a lot of tenants don't understand is landlords often have mortgages and other expenses that they have to pay, and they're relying on the rent that's coming in from the tenant in order to pay those expenses. So if they can't give that, then they'll go ahead and.
So what happens? Yeah. So what happens if a tenant is? Okay, we serve the tenant, right, with the pleadings, and then what do they have to do? How long do they have to respond, and how does that whole process work?
Yeah. So let's talk about. Let's break it down. So we've got a notice is provided, whether it's a 3-day or 7-day. That period has expired, and we have received no response, or no compliance, no deal has been made between landlord and tenant. Then the landlord is entitled to file a complaint for eviction. Now, there's 2 different ways that you can file this complaint. The first way is called summary eviction. This is, hey, I just want to really get this person out. I'll deal with the damage issue later. Okay. With that, the tenant only has a very short period of time to respond, give an answer, and deposit funds in the court if it's a non-payment issue. Otherwise, the landlord would be entitled to summary eviction.
Now, we talked about this before. Now, talk about depositing rent at the court. So I didn't know this until you told me. So my impression was, if I provide a 3-day notice or serve a 3-day notice on the tenant, and then I start with the eviction process, I always thought the tenant, no matter what, had to deposit that money into the court in order to avoid being evicted quickly. But that's not the case, right? They could technically say the notice you provided me is not accurate, use that as a defense, and then delay the eviction, right?
Yeah, so let's talk about that. So let's say the landlord says, you owe me $1,500, and you are served with that complaint saying, hey, this guy owes me $1,500. He hasn't paid me the $1,500. Court, can you force him to deposit that $1,500 into the registry to show that it, in good faith, that he has the money. Otherwise, give me possession, right? And there's a quick way to get through that. If you, the tenant, say, well, listen, actually, the amount that I owe is $0, or the amount that I owe is only $800, then you shouldn't be responsible for depositing a full $1,500, according to the Florida legislature.
Of course,
right?
of course.
So potentially the landlord could say, oh, you owe me $10,000, right? That would be fair to the tenant who's on an $800 lease.
Of course, yeah.
So if you dispute the amount in good faith, then it's going to delay the requirement to be able to have to deposit that money into the registry.
So if they delay the requirement to deposit the money into the registry, does the eviction process still proceed, or do they how does that work?
Yeah, so it's going to move forward, but before they can get the issue of possession dealt with, they have to deal with the issue of how much is this tenant supposed to be depositing into the registry. And so a hearing has to be scheduled before a judge where the tenant can say, hey, my landlord says $1,500. I've deposited $700, which means we now have $800, which is left that I owe. And so this is the amount that I need to be depositing into the registry, not the $1,500.
Okay, that segues into my next question is how long does that process actually take? Because, I've heard horror stories, right? Like if you're in California, it's like years. I have a friend that lives in an apartment in California, and I just actually talked to him this morning, and apparently he has a neighbor that hasn't paid rent since like 2021. And it's like going on 3-4 years. And he said, I should do the same thing, just bank all the money and then go buy my own house somewhere else in another state. And I said, you're crazy, just pay your rent because that's going to affect your credit, right? So how long does that process usually take? So let's start from, the question I have is, let's start if it's just a summary, quick one where they put the money in court and it's a maintenance issue or they haven't paid. And then also if they delay it like we just talked about.
Yeah, so let's say for the landlord, all of the dots align, right? So the tenant hasn't responded. He hasn't deposited money into the registry. The tenant has been served. We filed all the affidavits we need because we need to put an affidavit of non-military service and that kind of stuff to make sure we're not evicting somebody who's on active duty just out there overseas. Everything works out. We get a default judgment, and then we go for an order for judgment for possession. That process, the quickest we can probably get it done is 30 days.
30 days. Okay. And that's if there's no like major, COVID type issues or some sort of pandemic or special emergency, like a hurricane, especially in Florida. We have a lot of hurricanes. So that could potentially delay the eviction process, right?
In COVID, we had a pause, a moratorium on evictions. For
that was crazy.
Different reasons. It was.
Yeah, I was very blessed. So, just kind of a side note, during COVID, it's so important, especially because we're talking about evictions now. It's so important to do due diligence on your tenants. Super important. Like we are very, I'm very particular. So, they have to have a great credit score. I don't really care too much about healthcare bills because obviously, if you're gonna have a heart attack or something, you can't prevent that, right? But a lot of these issues tenants can prevent, and they're just based on bad decisions. So, for instance, I do a background check, a credit check, reference check, income check. And then I also do another, comprehensive, legal check with courthouses and whatnot. And then we ask for first and double security. And I found, especially when I did that before COVID, all my tenants paid. Actually, one tenant delayed and they ended up paying a couple of days later because they got some sort of grant program. But we were very, very blessed that we didn't have a lot of defaults or anything like that. So that being said, so it could be delayed. So generally it takes 30 days.
Yeah, that's probably the fastest you can possibly get, and that's assuming that the clerk is getting back with you and there's not a backlog in the court system.
Which there is right now. Right. Obviously there's a big backlog depending on the county you're in or the jurisdiction you're in. There, it could go like we were talking about California earlier. It can go years, which is really crazy because that really hurts the people that pay their rent on time. And this particular person, from what I know, allegedly has the money and hasn't paid, and they're just doing it because they can game the system, right? And some people are very good at gaming the system.
Yep.
So if you get the judgment, everything goes through. You've done all the process, and you've gone through the judges, and you get a writ of possession. Right. When is that issued? Is that issued right after the judge says, "Hey, I order the possession of the property," or is there like a time delay after that as well?
Yeah, so the writ of possession typically is issued usually within a day of the final judgment.
Okay, so a day.
And it kind of depends on the county and the individual judges and how things work. But once the writ of possession is issued, we get notified through the online portal. So if you can get electronic notifications, you want to run into the courthouse and grab it and hand it over to the sheriff if you're looking to try and get this thing done quickly.
Now, how long will it take the sheriff to, like, how involved is the sheriff in this eviction process, right? So you give it to the sheriff, you pay a fee. Is there a fee you have to pay?
Yep.
And if you're representing clients, obviously, then you would pay the fee, and then obviously that'd be part of that eviction process.
Right.
But if you're just doing it pro se, that they would pay the sheriff a fee, and then the sheriff would go to the house.
Yep.
And then what would the
It's all
sheriff
based
do?
on the sheriff's schedule, of course.
Yep.
Right? And most sheriffs are able to get it done within 2 days.
2 to 3 days.
2 to 3 days.
Okay.
Okay. But it depends on, obviously, if there's a huge amount of evictions that come through the pipeline, then the sheriff's can be real busy.
Of course. Now, for the fee that you have to pay the sheriff, is that per county? Does that depend on the county? Does that depend on? Is there like a flat fee? How does that work?
Yeah. So the every county sets their own rate for that.
Okay, perfect. Wow. So does the sheriff actually go in when it's time to evict? I've never actually personally been there when that's happened, right? So I'm curious. But do you think does the sheriff go in there with the guns a-blazing, knock down the door, and say, "Hey, get out and get your furniture out," or do they start moving the furniture out on their behalf, or how does that work? Because I'm sure some people, I've never had this experience. Knock on wood. Did people have to? Did the sheriff stay there until they move all the possessions out of the house, or how does that work?
Yeah, that's a great question, and I would love to get a sheriff in here to tell us some of their experiences.
Yes,
because I'm sure there's some really interesting, some very sad, and some very crazy stories that come out. Generally, they're there to make sure the people are out. Okay, the possessions and things like that, they're not movers. They're not going to be tossing couches and throwing things out on the lawn. Necessarily.
So what happens if the sheriff evicts the tenant leaves, the locks are changed on the door, right? And the furniture is left in the apartment. Is there provisions in the Florida statutes that say you have to give notice, you have to sell it, what are those provisions if you know? I have no idea.
Yeah, so there's abandonment provisions with regard to those materials. The landlord is entitled to harbor those things, give notice to the tenant, and then charge storage fees, in fact, if they don't come and pick them up.
Oh, wow. So you charge storage fees, and then eventually if they don't pay the storage fees, you just basically sell the furniture at auction or something and hopefully recover some of your lost damages.
Right.
Okay. Wow, that's very interesting. So this leads into my next question now. Can a landlord be sued for handling an eviction wrong? I'm talking about the legal process, not self-help, right? I'll ask that question later on. So the landlord files the court pleadings, serves everything, has the sheriff go in and evict the tenant. And then, say 60 days later or something, the landlord gets sued for whatever reason for handling the eviction wrong. Does that happen often, and can it happen?
So really the biggest cause of action is a wrongful eviction, and that's going to be under Chapter 8367. Now, in commercial stuff, there's some separate causes of action that can arise simultaneously with the eviction process, breach of contract, other potential claims, surety bonds, stuff like that. But in a residential case, really most of the claims really have to be brought in that original case, right? We've got this idea that you should be bringing all claims at once, and that way you're not going before the judge every 5 minutes, coming up with a new reason to sue him. That being said, of course, if you get to the point where you're getting a final judgment, and then somebody's coming back later on, we're really more talking about maybe a default judgment, and then the tenant comes back after the default has been entered and saying, "Hey, I'm here," right?
Yeah.
Maybe I was in the hospital, maybe I was in jail, maybe I was somewhere else that nobody could find me, and I'm here and I want to fight this case. Right.
So does that happen? Can they open the case and restart it?
Yeah, most county judges are pretty liberal with reopening cases after an answer is received and a default has been entered.
Really? So even if you get the default judgment, a tenant could potentially delay the eviction even further by saying, I didn't see the default, I couldn't respond.
You could potentially serve or non-serve a potential tenant and then get a default judgment by the clerk, and then the tenant comes back out of the woodwork somewhere.
I'm sure there's horror stories. I'm sure there's horror
Hang
stories.
on, I want to fight this.
Yeah, that is
cool. Open it up.
So what are the most common mistakes you see in your practice that landlords make? Like commercial and residential, right? Like I guess any landlord, what are the most common mistakes?
Yeah, I think probably the biggest mistakes, not necessarily the most common, the biggest mistakes are self-help, right? If you're going in there and you're changing the locks and doing all this stuff without going through the legal process, you're going to be liable.
Now, self-help, for instance, is when you get angry at a tenant because they haven't paid and you go over there, guns a-blazing, and you go maybe with a, whatever, a loaded gun. Don't do that, but I'm just saying, I mean, sometimes it's Florida, right? It's the Wild West, and they start self-helping, changing locks, not letting the tenant back in, doing crazy stuff. I've seen in my practice, I've seen everything. Yeah, I mean, it's crazy.
Yeah.
So that's when if you're a tenant, you go get a lawyer probably and say, hey, this guy's,
And if you can't afford a lawyer and a landlord is doing something like that to you, then call legal aid.
Legal aid, yeah. They definitely have resources there to help you. And if you're a landlord and you've self-helped before, hopefully you've learned your lesson. Self-help is totally unacceptable. We're all humans here, right? And we all have, I think most people in general want to pay their bills. And sometimes people do go through a difficult time. So I'm not saying the rent shouldn't be paid, but make sure you're compassionate about evicting a tenant and don't go embarrass people because that's just shameful, right?
Yeah, and even if you don't have any kind of sympathy or empathy, you're going to do it once.
And
because guess what? Under 8367, there are severe damages that you can be liable for. You're going to be paying that tenant's attorney's fees and costs.
Yeah.
And you're going to be paying their actual damages, any consequential damages, or the value of 3 times the monthly rent.
Oh, wow.
Whichever is greater.
So if you're a landlord and you're considering doing it yourself and self-helping, maybe you shouldn't be a landlord at that point, right? There always is business risk, whether you're renting property, running and operating a small business or whatever, there's always business risk. So if you haven't accommodated for that and you feel the need to self-help, then you shouldn't probably be a landlord or own any kind of rental property, right? It's best to keep a professional, open communication. So that brings me to my next question. What kind of proof holds up in court? So obviously we talked earlier about text messages and emails and those kind of communications. What about pictures? If you let's talk about the landlord perspective, what evidence holds up in court or what should you bring to court, and vice versa, the tenant, if there's a dispute there, what kind of proof works?
Yeah, so fortunately or unfortunately, county court is a little more informal than a trial. It's more formal than than small claims.
Yeah,
but we do have evidence and rules that we have to follow for evidence. If you're going to be submitting bank statements or bank records or text messages, we do have to try and authenticate them. Of course, if you're not represented by an attorney, the judge is usually going to be a little more lenient with authentication. You can authenticate it yourself, that kind of thing. But it's a lot of, validating the information. So the most common type of evidence that we're going to be seeing and using in court is going to be, pay stubs, deposit receipts, and then obviously any kind of real receipts from an actual receipt book. People still use those.
Yes, it's Florida.
It's perspective.
It's 20 years behind the times, right?
And from the tenant's perspective, the same thing, right? They're going to pull those stubs out and say, hey, this is the proof that I gave it to you. Money order copies from carbon copies on those kinds of things.
Now, one thing in Florida, and again, this is specific to tropical climates, and maybe even the northern climates too, right? Utilities. So, if you're in a northern climate like New York or Illinois or Canada or wherever, you have plumbing. You have some serious damages if a tenant decides that they don't want to pay the utility bill or that they're being evicted and they're just not going to, they're going to use like whatever, blankets or something. Same with Florida, right? You have mold and you have, all these other issues that come along with not having AC on. So can a landlord add unpaid utilities? So if you maybe this has to be in the lease agreement, but if you're a landlord and you have a provision there that they have to keep power on, I think most leases include that now. They have to have power and water and utilities essentially. And the tenant cuts those utilities off because they're being evicted and they're whatever. Can you add those to the eviction damages either before or after or during the eviction process?
Yeah. So in general, as long as the lease provides the tenant is responsible for the utilities, then you can add that on to the amount that's owed.
So that's important to know, right?
Claim that against a security deposit.
Eventually, yeah. So what happens if there's not enough? I mean, obviously, if there's not enough money in security deposit, which is why I said earlier, we always get double security now, right? Because these issues have come up, whether it's in your practice or whether it's in just my professional, real estate broker investment experience.
Yeah, you do not want to leave a house in the middle of July in Florida when it's 105 degrees out and thunderstorms out, high humidity, 100% humidity. No power.
Now, this is a very interesting question, and I get this sometimes, not all the time. I haven't had it in a long time, but they'll come. The tenants will come and say, "Please, please, please, I have $500 to pay. My rent's $1,000. So, how do partial payments affect rent?"
Yeah, so this is highly case specific.
Yes.
Okay. So this really, and I'm going to give you some generic answers, but if you have a similar situation, you're watching this, please, please, please. Contact your attorney first, right?
Before you accept the rent?
Before you accept
partial
any
payments.
kind
Okay.
of payments.
Yes, now this is getting spicy. This is what I like.
It's kind of spicy.
Yes.
Okay, so most leases are going to say, if you got a professional lease that's drafted by an attorney, it's going to say a non-waiver provision, which basically means, hey, I'm not going to waive any of my rights inadvertently. And by inadvertently, I mean, if I say something to you that's supposedly going to waive it, and you try and use that against me in court, I'm going to pull up that lease and that's the non-waiver provision and say, hey, this non-waiver provision says that if I'm going to waive a right, it has to be in writing and signed by both of us.
So that protects you if that happens.
That's going to be the landlord's defense for a tenant that comes up and says, hey, I gave him $500 and he said it was fine for the rest of that month for me to stay.
Wow.
Even though my rent was $1,000.
That's really interesting. So that brings me to my next point. This is a little off topic, but always hire a real estate attorney to do your lease agreement. I've tried to do it myself on these like legal websites, DIY things, and they're always out of date. There's always issues that come up. If you use an attorney, at least they can help you defend or help you evict somebody, and they know the terms of the agreement. So it's going to save you probably money and hassle in the short term and probably the long term too.
Yeah. And there's another important thing I want to bring up about accepting partial payments. Okay. If your lease has officially ended, you give a notice, I'm terminating at the end of the month. The tenant hands you a check the first of the next month and you accept it and you deposit it. That is you now no longer relying on this termination and you're starting a new month to month. So now you've just given this person an extra 30 days at least.
Wow.
If it's a month to month of a new renewing lease.
Wow, that's crazy. So what if the tenant claims that the property is not habitable?
Yeah, so the statutes are very clear in residential that if the property is not inhabitable, that you cannot use that as a defense necessarily. Okay. Now, what you're supposed to do as a tenant is notify the landlord in writing. There's a specific procedure that says, hey, the AC stopped working. You need to come fix it right away, right? You get that in writing, and then the landlord has an obligation under Chapter 83 of the Florida statutes to turn around and start working on that if that was his responsibility under the lease, which it is usually.
So, okay, so we've already talked about the clause in the contract where everything has to be signed in writing. So verbal agreements, are they enforceable during an eviction? We've already sort of answered that question where you said everything has to be in writing, correct?
Well, we want everything to be in writing, but verbal leases are enforceable in the state of Florida, right? As long as there's an exchanging of money in exchange for occupancy of a premises, it's still enforceable.
Okay, perfect. So how does a landlord, knowing all the stuff or all the items we've talked about today, how does a landlord protect themselves legally when they're renting a property? Just a quick rundown.
Yeah, so obviously vet your tenants, try and figure out who they are, right? And if you see there are issues that increase the risk, make sure that you have a security deposit that can adequately offset that risk, right? Of course, you have to make a business decision in terms of what's market rate, and you can price yourself out of the market. But definitely understand and give yourself an informed decision before you let that tenant in.
So rent slow, evict fast. That's the goal, right? Like hire slow, fire fast. That's kind of the terminology, right? I guess. So if you had to give one tip to a landlord, a property owner, what tip would that be?
Hire an attorney.
Hire an attorney? It's worth it, huh?
Hire an attorney. There's so many things that people think that they know, but they don't know.
Yeah.
And things that they don't know, they don't know.
And then with the use of AI now, I mean, this happened to me. I'm using AI to do something because I needed it done quick. And I know enough about it to get me by, but I'm not an attorney, obviously. And it was wrong. And I'm like, oh my God. And that's happening so much now where people are saying, hey, I don't want to, hire an attorney because they're expensive or whatever their excuse is. And they use AI, and then they have to hire an attorney to help them not only get out of the hole that they dug for themselves, but now they've complicated their case a lot. So I think that's a very good learning lesson, is hiring an attorney. Well, I think that's all I have for today. And we'll look forward to our next show next week. And I hope you had a good week so far.
Yeah, hopefully it was informative.
I hope so too. Well, thanks everybody for watching. And I'm James White, and we got Andrew Easler. Thanks again.